So today, my colleague and I will be discussing the value and the effectiveness of protecting the trademarks in domain names. So in Malaysia, trademark is governed under the Trademarks Act and is defined under Section 3, Subsection 1 of the Act. In the modern days, internet with its unlimited advantage of the modern life has become a source of many newborn problems. One of the ever-increased problem which has been a subject to intellectual property issue is trademark infringement in domain names. Traditionally, trademark infringement exists when improper use of trademark result in the likelihood of confusion for customers. The phenomena of the internet has generated many challenges to the application of traditional trademarks law concerning trademark infringement, policy and brand enforcement. In Malaysia, the internet commerce with the inception of the first internet service provider that in turn gave rise to the inception of the Malaysian domain name registrar being the Malaysian Network Information Centre, in short, MYNIC. This entity was entrusted with the primary purpose of the regulation and subscription of domain names unique to Malaysia, or better known as Country Code Top Level Domain Names, in short CCTLD, bearing the domain name extension .com.my, .gov.my, .net.my and many more. The implementing .my are second-level domain names. To date, more than 30 million domain names has been registered worldwide, including those in Malaysia. It is clear that registration for domain names are easily available in Malaysia, but critical issues that remains unsolved in the right of ownership, such as domain names, authorized domain names, dispute, trademarks and service marks owners, and cyber squatters. The provision of Section 70B of Malaysian Trademark Act 1976 clearly sets out the provision with regards to protection of well-known in Malaysia. Proprietors of well-known marks are entitled to restrain by way of injunction the use of any mark that is identical or nearly resemble well-known trademark or essential part of the well-known mark without the proprietor's consent, and where such unauthorized use would likely to deceive or cause confusion to members of the public. The NYNIC agreement under Clause 12 is governed and construed in accordance with the laws of Malaysia, and registrar and NYNIC submit to the exclusive jurisdiction of the courts of Malaysia. Under Clause 2.6 of the agreement, for registration of domain names affirmed by NYNIC, with all applicants and registrants of domain names state that NYNIC does not have the duty to screen request domain names to determine whether the registrant is entitled to register or have any rights of the domain name, or whether the domain name may infringe upon the rights of the third party, thereby denouncing the liability of unlawful registration by cyber squatters, and those who do not own intellectual property to legitimately own specific domain names containing depriving of well-known marks. The obligation of all applicants and registrants of domain names in Malaysia is provided under Clause 3.3, Clause 3.6 and Clause 3.7 of the NYNIC's agreement. Despite the explicit, clear and precise stipulation that the Act is subjected to the statute and enactment of Malaysia, including the provision of Section 70B of the Malaysian Trademarks Act 1976 concerning protection to well-known marks, it is to be noted that registration of domain names using derivation of well-known marks are still permitted to parties who does not propose sufficient goodwill and or any legitimate expectation in intellectual property or for ownership of domain names. My colleagues will further discuss the value and effectiveness of the protecting trademarks in domain names.
Trademark is essentially another word for brand or brand name. A trademark can be any name, word, symbol, slogan or device that serves to both identify and distinguish a business or product from others in the market. Once you have trademarked your business, domain or product, if someone else make an attempt to use something similar enough to confuse customers, you have the right to legally protect yourself and stop the other party. A trademark name marks all of your products and services as yours and can also protect you from counterfeit products. Since a domain name serves as the primary indicator of what will be found on a particular website on the internet, a distinctive or memorable domain name is highly desirable. Further, the domain name holder may wish to trademark the domain name in order to prevent others from using it. However, the ability to trademark a domain name is limited. Two threshold requirements in determining whether a domain name should receive a trademark are as follows. Firstly, the domain name must be used as a trademark, and secondly, the domain name must be distinctive. If neither is true, the domain name is merely an internet access and it will not be entitled to receive a trademark protection. Under trademark laws in general, in order to be entitled to trademark protection, any word, phrase, symbol, or design or combination thereof must be distinctive from others. The same is true for domain names. There are different categories for mark for goods, services, or domain names, including firstly, fanciful marks, that is, an invented term with no dictionary meaning. Secondly, arbitrary marks, that is, common terms used with unrelated products. Thirdly, suggestive marks, terms suggesting the underlying product. Fourthly, descriptive marks, terms which describe the product. And fifth, generic marks, that is, common names for an item. However, if a domain name uses surnames, geographic names, or common descriptive terms, it will unlikely be afforded trademark protection, unless the owner can show a special and unique distinction. Generic marks are never distinctive and may never receive trademark protection. Domain name dispute became rampant mainly because of the jurisdictional issues within the cyberspace. 2016 was the year in which cyber squatting cases hit records. The US is the first country to introduce a legislation which is specifically for trademark infringement in cyberspace, known as Anti-Cyber Squatting Infringement Act 1999. In general, domain name dispute can be solved in the following manners. Firstly, by ADR mechanism. Secondly, by court proceeding. Thirdly, by agreement between the parties. Fourthly, by conforming to procedures for settlement of dispute entered in the domain name registration agreement. From a different perspective, choosing a domain name which is legally conflicts with any of the millions of commercial existing trademarks could subject the holder to an action for trademark infringement. In general, a legal conflict might exist if another website offers similar goods or services under a similar domain name. The domain name is very similar to another domain name, which would cause customer confusion. And lastly, the domain name is similar to the name of a well-known trademark.
Unlike the registration of trademarks, domain names are registered on the first come first served basis. For example, there can only be one apple.com, and if that domain name is already used by one company, other companies that use the word Apple as their company name or their trademark will not be able to use that domain name. In the Princeton Review Management Corporation and Stanley H. Kaplan Education Center Limited, Princeton Review and Kaplan Education Centers were competitors in providing course materials for students. Princeton Review registered domain names princeton.com, review.com, and kaplan.com. Kaplan Review requested Princeton Review to start using kaplan.com. The dispute was referred to binding arbitration, and it was decided in favor of Kaplan Review. The first come, first served basis is pretty unfair, as one company can exclude another company from using the same domain name legally. To make matters worse, the Network Solutions Incorporated (NSI), which is the fourth largest domain name registrar, only provides dispute resolution in challenging violation of registered domain names according to its domain name policy. The NSI does not provide any investigation of whether the applicant is entitled to the domain name he desires to register. In addition, the database of NSI Who Is only allows searches for company names and information, not trademarks. An investigation of trademark search facility, done similarly as the registration of trademarks, both have saved time and money for dispute resolution or court proceedings. In Malaysia, there are two registration systems for trademarks and domain names. The Trademarks Office for trademarks, while the NYNIC for domain names. The dual registration system allows one person to register a word as a trademark and the other person to register it as a domain name, which can cause confusion among consumers as they are likely to associate a word with one entity instead of multiple entities. Thought the severity of this problem is reduced through the implementation of guidelines, dispute resolution policy, and research service. Individuals or companies that run their business solely through online are highly advised to have their domain names be registered under trademark. For a domain name to be qualified for trademark protection, it must be distinctive, or distinction comes from consumer associating the name with the internet business, and the owner of the domain name was the first to use it to associate with the sales of goods or services. Trademark domain names will be protected for similar domain names that can deceive or consume consumers and cases of misspellings or variation on a top-level domain. Thought individuals and companies must consider the costs incurred and that more protection requires more money. The registration for trademark domain names has led to some controversy. First of all, various disputes between trademark and domain name holders regarding the acquisition of top-level domain.com are usually caused by the practice of cyber squatting, domain name hijacking, or warehousing. Generally, the common remedy for these disputes is a court order commanding the domain name owner to transfer the domain name to the trademark owner. Besides transferring domain names, deletion of the registration of domain names is another remedy given by the KLRCA. The KLRCA is not allowed to award damages or payment or compensation as remedies. Unfortunately, the order of transferring or deleting domain names tends to abrogate the issue regarding the special position of .com and undermine the existence of other top-level domain names that a trademark owner can register. Secondly, trademark protection aims to protect consumers from confusion or deception as to the origin of goods and services. However, with the allowance for domain names to be trademarked, the aim begins to shift to protect the trademark owner's business interests instead. This shift is most notable in the United States, where the courts interpreted commercial use widely to include registration of trademark as a domain name with the intention to trade in the name in cyber squatting cases. The United Kingdom courts follow the same interpretation. The courts decided that the exclusive goodwill of a prominent mark will be damaged by mere registration of it as a domain name, and there will be trademark infringement if domain owners sell domain names that are confusingly similar to registered trademarks. The courts also held that registered domain names help to pinpoint origin and are used in relation to the services provided by the domain name owner who traded in domain names.
Trademarks or service marks are provided recognition and protection in only those national and international jurisdictions where these are properly registered. This may not attain trademark protection worldwide. The domain names as trademarks or service marks are registered and protected at the entire global level supremely by only one organization, which is ICANN, or in long, Internet Corporation for Assigned Names and Numbers. Along with the national and international protection under the directly concerned national trademark law and diverse international trademark treaties of the world, any national or international trademark law is not fully capable of protecting a domain name in countries of the world over. And to meet this vital objective, the ICANN, with support of the WIPO or WIPO, World Intellectual Property Organization, prescribed the following two strong and strict measures: a rigorous and consensus system of registration of domain names with executed registrars by ICANN, and an efficient and effective dispute resolution policy named as the Uniform Domain Name Dispute Resolution Policy, or in short UDNDR policy. For dispute resolution under the UDNDR policy of October 1999, a person or entity may formally complain before the competent administration dispute resolution services providers listed by ICANN under Rule 4 Paragraph A that 1. Any specified domain name is very strikingly or confusingly similar to a previously registered domain name or trademark of the complainant.
2. Any accused domain name has been registered and is bluntly being used in a bad faith. There exists any certain case of trademarks infringement against complainant. Today, the domain name registrars duly authorized by the ICANN operate a dispute resolution procedure under the UDNDR policy for purposes of providing efficient and rigorous remedy against bad faith and abusive registration of domain names which violate the trademark rights of the complainants. Also, during 2011, 79 companies, including the Coca-Cola Company, Hewlett-Packard, Samsung, and others, signed a petition against ICANN new LTD programs, sometimes referred as a commercial land grab, in a group organized by the Association of National Advertisers. As of September 2014, this group, the Coalition for Responsible Internet Domain Oversight, that opposes the rollout of ICANN TLD expansion program, has been joined by 102 associations and 79 major companies. Partly as response to this criticism, ICANN initiated an effort to protect trademarks in domain name registrations, which eventually culminated in the establishment of Trademark Clearing House.
Having inspected the MYDRB all through this video, clearly the effectiveness of the MYDRB ought not to be disregarded. By looking at the lacuna in trademark laws, the UDRB and MYDRB have an incredible advantage effect in furnishing an increasingly uniform methodology concerning domain name debates, including cyber squatting. The MYDRB has surely helped control the act of cyber squatting and has thus helped trademark owners in repossessing fraudulently registered names in Malaysia. As the MYDRB likewise centers around whether the respondent has the right or the authentic enthusiasm for the domain name, it enables the respondent to keep utilizing the contested domain name where he is honestly utilizing the trademark, regardless of whether he is not the trademark owner. Above all, the MYDRB is practical and cheap when contrasted with bringing civil actions under the Trademark Act, resulting to allow trademark owners to ask for more than one domain name registration in one continuing if every one of the registrations are claimed by the same respondent. Final decisions are reached within a month or several weeks and at a sensible organization expenses. Likewise, domain names might be dropped or exchanged. The creator extols the MYDRB and considers it to be an answer in beating issues originating from national jurisdictions issues. Besides, there is a greater and prejudiced nature toward the parties required as specialists settle on decisions based on written documents submitted electronically and by courier. It is trusted that with the MYDRB, cyber squatting will very before long be an issue of the past. Moreover, the Malaysian court still holds jurisdiction to settle domain name cases. The Malaysian court have in fact ensured the privilege of the case Petroleum Nasional Berhad and Koni Kyong that concerns registration of domain name, specifically petronasdagangan.com, petronasgas.com, mypetronasdagangan.com, and mypetronas.com. Its individual determination being comprised of the Petronas mark, a huge household mark in Malaysia, having a place with the owner plaintiff. For this situation, the Malaysian courts allowed prohibitory injunction against the defendant avoiding consistent utilizing of the encouraging domain names. Likewise, in the case of Intel Corporation and Intel Card case, the Malaysian courts granted an interim injunction while bidding security to the plaintiff. To sum things up, the security sought to mark which are well known by the Malaysian courts and the dispute resolution given by the KLRCA in accordance with the MYDRB. It was great for Malaysia to start the following stage by managing the pertinent standard and methods for registration of new and existing domain names reliable with the Malaysian Trademarks Act 1976. Such coherent guideline of domain name registration, it would in reality recognize, create, and shorten further protected intellectual property of famous marks in Malaysia in the data segment basic to a country pushing ahead technology.